Welcome to the Foster and Relative Caregiver Training Drill on the role of a GAL in Wyoming. This should take you approximately 30 minutes to complete and is approved for 30 minutes of training hours. Be sure to print the completion form before you begin this video. You will need this form to answer your checkpoint quiz questions as we progress through the training. If you're ready, here we go!
Hi, and welcome to a foster parent training on the role of Guardian Ad Litems in Wyoming. Thank you for participating in these online modules that will help foster and relative caregivers in Wyoming understand the legal process more. Today we're going to talk about the role of Guardians Ad Litem in Wyoming. Guardians Ad Litem are attorneys who are appointed by the court to represent the child. My name is Stacey Obrecht, and I'm the Attorney Director at the Wyoming Guardians Ad Litem program. My email and phone number are here on the slide in front of you in case you have any questions following today's training. The first thing we're going to talk about today are the types of cases that are covered by my program. We cover abuse and neglect cases in juvenile court, child in need of supervision cases, delinquency, termination of parental rights cases that come out of juvenile court, appeals cases coming out of the juvenile court to the Wyoming Supreme Court. If it's a delinquency case, we do not cover public defender's representation of children, only the Guardians Ad Litem if they're appointed to that case. There are a lot of other cases in Wyoming that have Guardians Ad Litem appointed to them that are not covered under the program, and those are listed on the right for you, some of which are guardianships, adoptions, private divorce and custody cases. For example, if parents are fighting over the custody of their children, those attorneys are not under my program. Adult guardianships, child support, paternity, ICJ, which is Interstate Compact on Juveniles, and many others. A GAL in Wyoming gets appointed in abuse and neglect cases. It's a mandatory appointment, meaning that every abuse and neglect case will have a GAL on it. In chins and delinquency cases, it's discretionary. It's up to the court to decide when to appoint one, and the statute says that they can appoint one if the parents are gone or if the parents' interests are adverse to the child's. There's a very big difference between a direct attorney and a guardian ad litem that I'd like to talk about first. A direct attorney, a direct lawyer, takes direction from the clients about the objectives of the representation. And in the end, after an attorney has counseled their client, the client gets to decide how to move forward with the case. A guardian ad litem is not bound by those wishes. They can act in what they believe is the best interest of the child. Ad litem means at law, meaning we are not guardians that take care of children or that watch their money. We are there to represent the legal interests of the child. And the client is the child, not the judge or DFS or the MDT team. It is the client. There are many types of GAL representation and child representation in the United States. I'd like to go through the 4 types and show you that really the 4 types are present in Wyoming in different situations. Our main default position is the hybrid model of representation, which I'll talk about last, but we also have the other 3 types at different times. The first is having a pure lawyer. This is where the child gets an attorney to represent what they want, and that client is bound by that direction. In delinquency cases in Wyoming, a public defender is appointed for the child, and that is a pure lawyer direct attorney representation. Also in chins proceedings, the statute gives the child a right to an attorney, a direct attorney, and if that child does not waive that right, that attorney will be also the pure direct lawyer representation model. The next is the pure best interest guardian ad litem. This is where the GAL is responsible for deciding what's in the best interest of the child and does not have to take into consideration what the child's wishes are. In delinquency and chins proceedings, if a GAL under my program is appointed and there's also a public defender or an attorney for the child in that case, the GAL through the GAL program will take on this pure best interest representation model. You'll have sometimes both a lawyer and a GAL. This is where in some states every child gets 2 attorneys. They get one that's going to represent what they want and one that's going to represent what's in their best interests. In Wyoming, this happens in some delinquency and chins cases where there's a peer lawyer and a best interest lawyer. Now, the default representation model in Wyoming is the hybrid model. The Wyoming Supreme Court said that this is how children should be represented, and the GAL program rules say that this is the model to be used. This is where you have one GAL doing both roles, representing both what the child wants and what's in their best interests at the same time. So in every abuse neglect case in Wyoming, this is the model that will be used, and in some chins cases, this is the model that will be used.
So you've learned about a GAL's representation in Wyoming courts. Let's take a quick quiz on what we've discussed so far. What is the type of GAL representation in an abuse neglect proceeding in Wyoming? Please choose one of the following. Is it A, peer lawyer, B, best interest lawyer, C, hybrid role lawyer, or D, two lawyers, one to represent the child's best interest and one to represent the child's wishes? Please take a few moments to think about your answer. If you answered C, hybrid role lawyer, then you are correct. Although Wyoming has all four types of child representation at different times, all GALs appointed to represent children in abuse neglect proceedings take the role of a hybrid attorney.
I'd like to talk for just a moment about the child's right to counsel because it does come up in delinquency cases and can sometimes be an issue in a chins case as well. This is why a public defender is appointed for children in delinquency cases. The United States Supreme Court said that the Sixth Amendment of the Constitution says that any person accused of a crime shall have the assistance of counsel and effective assistance of counsel. And in re Galt, which was a case from that Supreme Court, they said that this right applied to children. Because they face that loss of liberty, that imprisonment, then they have the right to an attorney to represent them if they can't otherwise afford one. As a side note, there is a national movement towards all children having a right to counsel, not GALs, in all juvenile court cases. That's not what we have here in Wyoming, but there is a national movement towards it.
So you've learned about a child's right to counsel. Let's take a quick quiz on what we've discussed so far. A child in a delinquency case has the following right given by the United States Constitution. Is it A, GAL, B, a court-appointed special advocate, C, bail, or D, a direct lawyer? Please take a few moments to think about your answer. If you answered D, a direct lawyer, then you are correct. A child accused of committing a crime and subject to potential loss of liberty, detention, has a constitutional right to be represented by a direct lawyer. If the child cannot afford an attorney, the court will appoint a public defender to represent them in a proceeding.
The next thing I want to talk about are our GAL program rules and regulations. These were effective December 4th, 2008 when the GAL program was moved from the Supreme Court to the Public Defender's Office. I have the website up there for the GAL program. You can find these rules and regulations on that website by going to the resource page and then clicking on rules. It'll be the first link at the top of that page. As a side note, the program website has a lot of other information on there that you might be interested in. It has resources and also has the GAL panel, which lists all the attorneys in each of the counties that do work for us, either employed or contracted. And if you click on their names, it has their phone number, fax, and email address. So if you need to get in touch with one of the GALs for a child that's living in your home, that would be a good way to do it. The GAL program rules set forth qualifications and training that are required before a GAL can do work with the program. They must have an initial 10 hours of live child-related training within the last 2 years. That can also be satisfied by taking a course at the law school called Children in the Law, or participating in a clinic at the law school and coming to our annual conference while in that clinic. They must, of course, be an attorney in good standing with the Wyoming Bar. They must apply to me with a release so I can ensure good standing with the bar and CLE compliance. And then each year after they're employed or contracted with the program, they have to have a continuing 5 hours of that CLE, that live child-related training every year. I want to quickly go through the 5 guiding policies that are set forth in the program rules so that they kind of give you an idea of what the GAL program's overarching goals and policies are. First is that each child is valued as a unique human being, regardless of race, ethnicity, religion, age, social class, physical or mental disability, gender, or sexual orientation. Second is that each child is vested with certain fundamental rights, including the right to physical and emotional health and safety. In order to achieve this, we must promote legal rights and remedies for children, including empowering children by ensuring that courts hear and consider their views in proceedings that affect their lives. So a GAL's role is really to promote those legal rights and remedies and to make sure that their view is heard in court or that their best interests are heard in court in those juvenile court proceedings. The third guiding policy is that every child subject to a child protection proceeding must be provided an independent, competent, and zealous attorney trained in the law of child protection and the art of trial advocacy with time and resources to handle the case. So it's important to note that the attorneys should be independent. They shouldn't always side with DFS or always side with the prosecutor in every one of their cases or the parent's attorney. They need to decide for themselves what's best in that case, and that may mean that they side with the DFS worker or the prosecutor or with everyone, but that they have to independently come to that decision. They must, of course, be competent, and zealous is a word that we use in the law for being a good and straightforward advocate that really works hard for their client. The fourth policy is that children's attorneys play a critical role in empowering children and ensuring that their views are heard in legal proceedings. Outcomes in the adversarial process are directly tied to the quality of legal representation. Additionally, the presence of children's attorneys are critical to ensuring the timeliness of proceedings. So as you get more into this area, you'll learn about the timelines in these cases, both state and federal timelines, and how important it is that we work through these cases quickly, that we get children back home quickly or get them to permanency quickly, and how important that is for the stability of their lives and their own well-being. The last guiding policy is that children's attorneys play a critical role in advocating for permanency and for the continuation of familial relationships, family preservation, and family and community placements where appropriate. So it's important that they actually advocate for that quick move home or quick move to permanency. They must also advocate for food, shelter, clothing, and safety, including a safe temporary placement where necessary, and for educational, medical, mental health, and dental needs. And that they should also advocate for continuation of appropriate familial relationships and against out-of-home placements unless they're needed. So although that they're representing the child's legal rights, the rules do set forth that those legal rights are going to also contain lots of other well-being and health issues that the lawyer has to advocate for and be aware of.
So you've learned about the GAL program's qualification requirements. Let's take a quick quiz on what we've discussed so far. In order to qualify as a GAL in Wyoming, the following must be true. Is it A, you must be an attorney, B, you must be in good standing with the bar, C, you must have 10 hours of live child-related training, or D, all of the above? Please take a few moments to think about your answer. If you answered D, all of the above, then you are correct. People often confuse CASA advocates with GALs and believe a GAL can be anyone in Wyoming. A GAL must be an attorney in addition to the other qualifications listed in this training.
The rules define a GAL's role on page 2.1 in Chapter 2, Section 2, and talks about that hybrid role that we've already discussed, but also defines kind of what a child's best interests really are, which is an issue that I think lots of people struggle with. So the definition is that it refers to a determination of the most appropriate course of action based on objective considerations, and note it's objective, not subjective, of the child's specific needs and preferences. The determination of best interest should be based on objective criteria as set forth in the law that are related to the purposes of the proceedings. It should address the child's specific needs and preferences, the goal of expeditious resolution of the case so the child can remain or return home or be placed in a safe, nurturing, and permanent environment, and the use of the least restrictive detrimental alternatives available. This determination must include the presumption that it is in the child's best interest to be with his or her parents, as outlined by the Supreme Court in a case that they decided in 2006 called In Re Guardianship of MEO. I'm next going to go through the GAL's responsibilities that are listed in the program rules, and there's quite a few of them. I'm going to go through them fairly quickly, as you can look for more detail later on in the GAL rules if you have a specific issue that comes up. First is that they have to possess the knowledge and training necessary. So we have an annual conference, we have lots of training during the year, and then of course there's the requirements of that initial training and ongoing training. They have to be familiar with national standards and best practice procedures, be familiar with the dynamic of domestic violence and the co-occurrence. So there's a high co-occurrence of child abuse and neglect with domestic violence. Conduct a full and independent case investigation in a timely manner. Counsel the child concerning the case, the GAL's role, the child's rights, possible outcomes and consequences of the child's lack of participation. Before making an out-of-home placement recommendation, they must research and consider all of the alternatives. Independently identify and advocate for appropriate family and professional resources. Participate in the legal process, which includes depositions, negotiations, discovery, MDTs, and hearings. And make independent recommendations with an emphasis on community services most likely to preserve families. They have to encourage the presence of children at hearings and MDTs, review court orders for compliance with law, monitor and advocate for timely implementation of the case or permanency plan, and then attend all MDT meetings. Unless they can't, then they can attend by phone or submit a written report before the meeting. The rules do note that the obligation to be the child's GAL does not cease until they are formally relieved by the court or the court case closes, and that includes any appeals or TPR proceedings that arise out of that underlying juvenile court case. The last one I want to talk about is that they have to independently investigate the case, and the rules go on to define this as really three different things. First, that they have to obtain information about the child and the circumstances that led to the petition. And the petition is the first legal document that's filed that starts a case, so that's what sets forth the reasons why the state has intervened in someone's family life and taken custody of a child or come in to watch over the safety of that child. They have to meet with and observe the child's interactions with caregivers at home or in placement, and personally meet with the child in a timely manner. And we actually have a policy on our website that you can look at that details very clearly what the responsibilities of the GAL are about meeting with a child, and also meeting with a child in a caretaker's home, which would be a foster relative caregiver's home. Failure to do these things can result in immediate termination of the contract or employment, and also non-payment of the bill.
So you've learned about a GAL's responsibilities. Let's take a quick quiz on what we've discussed so far. The following statement refers to which GAL responsibility? A GAL must obtain all information about the child and the circumstances that led to the petition, meet with and observe the child's interaction with the caregivers, and meet with the child within 30 days of being appointed to the case. Is it A, the responsibility to independently investigate? B, the responsibility to counsel the child? C, the responsibility to participate in the court process? Or D, none of the above? Please take a few moments to think about your answer. If you answered A, the responsibility to independently investigate, then you are correct. Remember that failure to do these three things that constitute the responsibility to independently investigate a case can result in non-payment of bills or termination of the GAL's employment or contract with the GAL program.
We also have set forth caseloads in the GAL rules. A part-time GAL can have no more than 40 clients at a time, and a full-time can have no more than 80 clients. We count by client, not by case, so if a case has 6 kids on it, we count that 6 times, as we expect that the GAL will probably get to know all 6 kids, and it's going to take more time to work on a case with 6 kids than it would on a case with 1. The rules say that the program will strive to keep caseloads below the maximum, and that I will monitor each of the caseloads and weigh them, and the factors to weigh those are listed before you. I can also limit appointments if there are other obligations that interfere with the GAL's ability to provide the services, regardless of the number of cases. So they may only have 1 case, and I can still limit that if there are other work in their private practice is interfering with their ability to provide competent GAL service. I wanted to talk to you a bit about the formal complaint process. We do have a process by which anyone involved in a child's juvenile court case can make a complaint about the Guardian Ad Litem. If there's an issue, if they're not following the rules or the policies, not meeting with the child, etc., then that formal complaint can be filed. It can be filed by a foster relative caregiver or anyone else involved with the case. It can also be filed by the client if they're old enough and are willing. There's a link before you to the website. You can also get there by just going to our website, and on the left there's a link to the formal complaint policy and forms. I do want to note that it's not anonymous. It's important for us to have all the information and be able to follow up in the investigation. Once we receive a formal complaint, that information is then forwarded to the attorney, who then reviews it and responds in writing, and then I investigate the complaint and then make any decisions from there. The GALs are told that if they retaliate in any way towards the person filing the complaint, that their employment or contract will be terminated immediately. So I just want to note that although it's not anonymous, there should be no retaliation from filing that formal complaint.
So you've learned about a GAL's caseload. Let's take a quick quiz on what we've discussed so far. Please consider the following scenario. A GAL is assigned to a case in Natrona County. The GAL program receives the petition on the case, and it involves 4 siblings. How many cases will be added to the GAL's caseload? Is it A, 2 because 3 of the kids are living with Grandma and the other one is still at home? B, 4? C, none because the GAL is already at their maximum caseload. They will have to bill the county for this case. Or is it D, 1? Please take a few moments to think about your answer. If you answered B, 4, then you are correct. Remember that the GAL program counts the GAL's caseload by client, not case. This means if a case has 4 siblings, the case is counted 4 times. because the GAL is expected to know and advocate for each child individually.
Let's talk a little bit about the interaction between GALs and foster parents. A lot of questions come from foster parents about what information I should share with the caseworker, what information I should share with the GAL, and my advice is to always share information about the children with the caseworker. They're the guardian, they're the ones that have that legal custody of the child, but you can always call the GAL as well. The caseworkers usually forward that information to the GAL, but if that's not happening or you'd like to tell it firsthand instead of secondhand, you can always call the GAL, and lots of them will really appreciate that extra information. The GALs do have a requirement to work with the biological parents until the courts relieve DFS of any reasonable efforts with the parents. So the GAL is going to be talking and working with the biological parents. A lot of times the foster relative parents are also asked to work with them and help with visitation or help support that biological family so that they can get their kids back home. You will probably have a lot of contact with the GAL. In addition to seeing them at hearings, court hearings, and MDTs, they will probably come to your home to visit with the children. They may call you to check in. You may see them at doctor's visits or at IEP meetings at the school. There's a lot of different places that you may see them. If you have issues with a GAL, feel free to call me, email me, or also use our formal complaint process. I'm always open to discussing an issue. Even if you're not sure that it is something that should be a formal complaint, you're always welcome to call me and talk to me about it.
Congratulations! You made it to the finish line. Be sure and submit your completion form to your foster care coordinator in order to receive training hours for this video. Thank you for your time. We hope that you have found this helpful.